Presentation of Dialogue on Idaho Public Television is made possible through the generous support of the Laura Moore Cunningham Foundation, committed to fulfilling the Moore family's legacy of building the great state of Idaho.
It's clear that at the highest levels of the government, people were involved in the decision to torture. And, I'm sorry, but that's a crime.
Coming up next, a conversation with Idahoan David Nevin, the lead attorney for one of the most high-profile defendants in the world, Khalid Sheikh Mohammed. That's Dialogue next. Stay tuned. Hello and welcome to Dialogue. I'm Marcia Franklin. For most Americans of a certain age, September 11th, 2001 is seared into their memory. But how many people know what's happened to those charged with planning the attacks of that day? My guest today is quite familiar with what happened to one of those individuals. Idaho attorney David Nevin represents the most well-known defendant in the case against the alleged 9/11 plotters, Khalid Sheikh Mohammed. Mohammed has been in custody since 2003. For more than 3 years, he was held in secret CIA black sites around the world and subjected to enhanced interrogation techniques that many regard as torture. Since 2006, Mohammed's been in prison at the Guantanamo Bay Navy base in Cuba, where he's been charged with nearly 3,000 counts of murder. And since 2008, Boise attorney David Nevin has been his defense counsel. To say it's a difficult case is to put it mildly. Mohammed has confessed to being the, quote, director of planning and execution of 9/11 from A to Z. The court proceedings themselves are slow and shrouded in secrecy, with scenes that sometimes seem like something out of a movie. Mr. Nevin is no stranger to tough cases, though. In 1993, he successfully represented Kevin Harris, who was charged with killing a deputy U.S. Marshal on Ruby Ridge in North Idaho. And in 2004, he convinced a jury that Sami Al-Hussein, a University of Idaho graduate student, was not a terrorist. This case, though, has now consumed 7 years of Mr. Nevin's life. Indeed, some have called it the forever trial. And here to talk more about all of this is David Nevin. Welcome.
Thank you.
Welcome to you. Well, you and I last talked 6 years ago, I believe. And at the time, things were going slowly then, but there was some optimism that things would pick up. Did you have any idea that 6 years later we'd still be where we are today with the trial not even starting yet?
Yeah, the expectation at that time was that the case would be moved to federal court in Manhattan, and there was an attempt to do that. But ultimately, the Obama administration resolved all that by restarting the proceedings at Guantanamo Bay. And we did that in 2012, and as you say, we're just now getting off the ground a little bit with that case.
So if this were a train and it was on a 100-mile track, where would we be?
I think we'd still be getting up speed leaving the station.
Really?
Really.
After all these years. We'll talk about the reasons for some of these delays, but let's first remind our viewers how you got involved with this case to begin with and why you took it.
Yeah, I was originally part of something called the John Adams Project that the ACLU, the American Civil Liberties Union, and the National Association of Criminal Defense Lawyers organized. And up through the first round of commissions, up through around 2010, that's how I was paid. Now I'm appointed counsel and paid by the government, and have been involved, just as you said before, since 2008, some 7 years now.
How does a guy from Boise, Idaho get involved in a case this large and this far away?
Right. Well, you mentioned the Al-Hussein case, and after my partner Scott McKay and I worked on that case, we then handled a number of other cases of terrorism and alleged terrorism around the country. And when the ACLU and the National Association of Criminal Defense Lawyers decided to put this project together, they contacted a number of lawyers from around the country to come in and try to provide some assistance in this situation, and Scott and I were recruited to do that.
Why was it so important to you to take this case, which was going to keep you away from family for long periods of time, is very secret, sometimes frustrating, potentially dangerous?
Yeah. Well, the system is designed that in such a way that it only works if there's a lawyer who will stand up for the defendants. And I felt that I, for whatever reason, was called to do this, and that it was important to see it through. And I still think that. It's difficult, time-consuming. I spend more time on airplanes than I would like, and there are many frustrations, and there's much to suggest that it would be better not to be involved. But I think it's important to see it through.
Well, and you're lead defense counsel for a man that's reviled by many.
Well, I'm lead defense counsel, but my team operates very much on an egalitarian basis. But as for the remark about being reviled, people, I think people are willing to accept that a lesser form of justice could be appropriate based on what the allegations are about what someone did. But that's not the way justice in the United States works. We afford everyone the same treatment, and we follow a process that has been enshrined in the annals of justice over many, many years, and that people have fought and died for. And then we let the chips fall where they may. And the troubling thing about this situation is that we've done something different now for the first time. We've put our finger on one side of the scales, and it's quite unfair and quite wrong.
Meaning?
Well, what I mean is the military commission system was created out of whole cloth for these cases. And when you have hundreds of years of experience in delivering justice in the courts of the United States, many of the kind of fine-grained questions about procedure and process have all been resolved. But when you have a new court system, they all have to be resolved again. And the government takes the position that the United States Constitution doesn't apply to these cases, and so everything has to be litigated.
And that's why, in large part, there's been so many delays over the years, because this is almost a new branch of law that you're creating.
Well, not large part. That's part of the reason for the delay, but it's actually a rather small part. The primary reason for the delay has been the extraordinary lengths that the government has gone to spy on us and to spy on the defense teams. Quite remarkable developments that I would never have thought would be possible in the United States. But
well, let's talk about some of those incidents. It came to light that the FBI had, for want of a better word, is infiltrated the right word?
Infiltrated is exactly the right word.
Two defense teams. There are 5 people being tried, 4 other people along with Khalid Sheikh Mohammed, your client. 2 teams, including yours,
right,
were infiltrated, meaning?
Meaning that FBI agents approached members of the team in secret, interviewed them about team activities, enlisted them to be continuing informants, told them to keep it quiet, not tell the members of the defense team. And, it's Law 101 that the relationship between the attorney and the client is sacrosanct, that the actions of the defense are confidential and required to be kept confidential. And to have a law enforcement agency seek to find a back door into the secret conversations of the defense is astonishing. I've never heard of that happening in my life.
Did it come to light, or did the person on your team let you know?
Well, ultimately the person did, and that came some year or so after the events took place in response to the military judge issuing an order saying, look, anyone who's had contact with the government, come forward now and tell your learned counsel about it. And that's when my team member came forward. And that person had been put in a very, very difficult position because that person had been told that the security clearance that person was extremely important to that person would be called into question if they didn't cooperate. They were put in a very, very difficult position. And
I can't imagine the emotions that you must have had knowing that somebody on your team was compromised, well, that the team was compromised in that way.
Yeah, you do have a tendency to look around and think, where exactly are we here? What's going on? Who's next? And it's very, very, and it's very, in terms of client relationships, and you're talking about a man here who's been tortured repeatedly at the hands of the United States, and wonders whether lawyers care about defending him, wonder if it's possible for them to. And then it turns out that the security agencies are doing these kinds of extraordinary actions. It's very corrosive to client relationships.
Even when you're in Boise, Idaho, do you look around your shoulder? Do you worry about such things? Or are you concerned, I should say?
Absolutely. Yeah. All the time. All the time. I assume that my telephone calls are being listened to. I assume that my email traffic is being reviewed, and I have evidence that it has been. So that's another, something like a dark cloud hovering over your actions every day.
And another team member discovered that what looked like a smoke detector was actually a listening device where you were
in our meeting rooms.
Attorney-client meetings were happening.
Yes, and one day I was speaking in court, and suddenly the red light goes off, indicating that I have maybe said something that was classified and that I should not have said. It turned out I didn't, but nonetheless, the red hockey light goes off, and the judge and his court security officer look at each other, and it dawns on them neither of them pushed the button. No one in the courtroom had pushed the button.
So we should say to tell viewers that there is this system where people watching are on a 40-second delay, and if something is said in the courtroom that could be deemed a violation of secrets, the judge or another person in there can hit this this button. But in this case, neither had.
Yeah, you say hockey because it is like the goal, the light that goes off when you score a goal in a hockey game, and literally it circles around and around, red flashing light on a stanchion right next to the judge's podium desk. And as it turned out, no one in the courtroom had pushed the button. It had been pushed by the CIA, which was listening in another place. And no one knew, or at least no one, at least not the judge and not the defense, knew that the CIA had the technical ability to do that. And so we take their claim that they're not listening with a grain of salt, with a pound of salt.
And this has slowed down the proceedings significantly. I want to mention as well, you discovered that one of the men who's on trial looked over and saw a translator in the courtroom that he recognized from one of the so-called black sites where he had been subject to enhanced interrogation techniques. So that person was on the defense side, right?
You're referring to an interpreter who was a former CIA employee who was employed by the Ben al-Shib defense team. And I say that in that way because that's all I'm allowed to say. The government imposed that little script on me and requires me to repeat it in exactly that way. But yes, that's what I just said is what happened. So if you've been tortured over a period of time, and if you were then told, well, that's all over with and you're now going to be treated fairly and we're going to have, a justice system that functions correctly, and if you now then find that someone on your defense team is someone who was with us in the black sites, to quote what Mr. Ben al-Shib said in open court, you get the message. The message is, you thought we didn't have power anymore over you? Well, think again. And again, this kind of thing is completely inconsistent with the way justice is supposed to be dispensed in the United States.
How often have you been able to see your client, Khalid Sheikh Mohammed? I know in the beginning he rejected counsel. Has that changed, and do you see him regularly?
Yes, and I served as standby, Scott McKay and I served as standby counsel for him for quite a while, and as he was representing himself. But those charges ultimately were dismissed around the time that President Obama said that he was going to close Guantanamo and shut down the military commissions. Since these new charges have been initiated in 2012, Mr. Mohammed has accepted representation in the sense that he did not object to being represented by counsel. And so I and the other team members have been serving as his counsel.
So how often are you able to see him?
We have someone there visiting him almost every week. There are some exceptions to that, but we meet with him frequently.
What is his? What are you able to say about him as a person?
Not much, but I will say that he is a person who has always treated me respectfully and has been good to his word about the things that he's told me, is enjoyable to spend time with, and bright and intelligent, and is a client that I have enjoyed working with.
Now, he has confessed to being involved in 9/11 at a high level, but your contention is that that confession came out under duress, under what we now know are multiple enhanced interrogation techniques that came out in a U.S. Senate report on the issue.
Yeah, enhanced interrogation technique is a euphemism for torture. What was done to him is unquestionably torture. The Senate Select Committee on Intelligence's executive summary, which was released last December, concluded that without any doubt. Yes, he, I mean, I suppose most, in the clearest fashion, would be the Combat Status Review Tribunal, in which Mr. Muhammad said that he was responsible for the attacks of September 11th. And I think for purposes of a discussion like the one we're having, we can simply assume that that's true. He is a torture victim. And the history is that people will say anything if they are tortured. And so, on the one hand, I take it that, that's true, that he's the planner. But I also keep in the back of my mind that he was tortured, and that once you acknowledge or admit to something, albeit under torture, it becomes difficult to take that back.
What surprised you most when you read the executive summary of the report, the Senate Select Intelligence Committee?
That what surprised me the most was the clear acknowledgement that the people who committed the acts of torture committed rape. They raped these people. They also tortured them. Torture is a 20-year felony under United States law, and rape is a life felony in most states.
You're talking about the rectal rehydration that occurred?
Yes, rectal rehydration done without medical necessity for the purpose of controlling behavior. And again, rectal rehydration is a euphemism for penetration with a foreign object. And so the clarity and the open way in which it was revealed that these things had taken place, and the brutality of it, was surprising even to me, and I'd had plenty of opportunities to talk to my client about it.
Now, as I mentioned, you've read the executive summary, which is a little under 600 pages. That is, the full report is 6,000 pages, yes?
That's what we're told.
You have not seen it?
No.
You would like to?
I would.
It is based on 6 million documents.
Correct.
Would you like to see those?
Of course.
Will you keep the trial, will you keep delaying the trial until you do, making motions to see them?
Oh, absolutely. We're absolutely entitled to see those things. There's really no question about it. Many of these documents were classified to protect people who committed these crimes. And but now one of the effects of the release of the Senate torture report, the summary, as you say, of the full report, is that many of these things have been declassified. So large portions of these 6 million pages and these 6,000 pages of the report should now be, there can't really be any claim anymore that they're classified. And they're clearly relevant, and I assume that at some point the judge will order that they be provided in their entirety.
Your client has seen the summary?
Yes.
And are you able to say what his reaction was?
No, I can't say that in any detail, but you just imagine that you have a somewhat clinical discussion of these things that occurred to you these years ago, these long years ago, and there's a huge problem with torture survivors. And actually, torture is fairly common around the world, as you probably know, and there are many people who've made a profession, a life's work of studying the effects of torture. And one of the big issues is recapitulation. All sorts of things bring it back. And this had the effect, I think, of recapitulating for him.
Some watching this might say, well, Mr. Nevin, all sorts of things bring back 9/11 for the families of the victims of it, and that we should not feel sorry for somebody who admits that he was involved in planning those attacks.
Right, and I should say, my role here is as criminal defense lawyer to defend Mr. Muhammad to the best of my abilities. And I don't mean by any of the steps or the actions that I take to demean the suffering and loss that the many victims of September 11th went through and are still going through. But there is no denying, whether you like it or not, there is no denying that torture has this effect on people. And of course, the torture has to be discussed because it's a factor in deciding whether or not the death penalty should be imposed.
Now, prosecutors have said, yes, that they won't use confessions obtained under duress, that they would use confessions only from so-called clean teams that came in and re-interviewed the individuals when they were not subject to these techniques.
Right, so I torture you for 3.5 years and then I say, hey, that torture's all over with, but could we talk? And you proceed to tell me a bunch of things. Really? That's a voluntary statement when you're still in my custody? And yes, maybe it's a different alphabet soup agency than the one that tortured you, but what do you know about that? That's not really a voluntary statement. So there are many questions yet to be resolved about what, if anything, the government can use from these many statements that they say were made.
I watched a fascinating 5-part interview on Fox News with Dr. James Mitchell, who's one of the people who has admitted to waterboarding your client. And I'd like to play a clip from that and get your reaction to it.
Was it torture?
Not in my mind. If it was torture, I would be in jail. This thing was investigated over and over and over. I was told by the highest law enforcement agency in the land that we were going to walk right up to the edge of the law, and that all the things that we had included in that list were legal. So in my mind, and I know there's this controversy about whether
did it feel like torture when you were doing it?
You know what, ma'am? It felt like I was doing my duty. I didn't like it. I didn't enjoy it. I wasn't thrilled by it. I found it repulsive at times, but I sucked it up and did my duty to keep people from dying.
He feels as if he was doing his duty, he was saving more lives by doing this, and that it was authorized.
Right, and let me begin by saying that I can't confirm or deny that Mr. Mitchell did anything to my client or to any of the other people. I'm not allowed to speak about that. He can get on television and say it. I can't confirm or deny that it's true. So let's just talk about it in abstract. That's called the Nuremberg defense, right? I didn't do it. Someone else told me it was okay. That's not a defense. It's just not a defense. And he saved lives by torturing people. The Senate report, which, as we've just been saying, scoured 6 million pages looking for the evidence and talked to hundreds of witnesses, came to the conclusion that you can't say that. It's not true. And people who've been involved in interrogation for many years and are expert at it know that you don't get useful information by torturing people. He is not in jail. Even though he committed 20-year felonies, he's not in jail because of the secrecy regime that has been imposed on these proceedings.
Do you think that people at the highest levels, meaning the former president, vice president, should be tried for war crimes?
Well, I think that there is an idea of conspiracy, and in the context of war crimes, it's controversial. But it's clear that at the highest levels of the government, people were involved in the decision to torture. And, you know, I'm sorry, but that's a crime.
Where do we go from here? We, meaning the American public, because the American public is paying for this.
It's clear to me that at this point, this system is broken in a way that is inconsistent with the requirements for due process and reliable outcomes that the U.S. Supreme Court has made clear have to be present in capital cases.
So it needs to be shut down?
Well, the big issue that remains here is the death penalty. The death penalty is what is driving this. It's the reason I'm there, and it's the reason many of the other lawyers are there, is because Congress required that in a capital prosecution in a military commission there have to be lawyers who are learned in the law of capital punishment. And if you take death off the table, then you have a very different kind of proceeding, and you have very different kinds of rules that apply. But the point is that to be a regularly constituted court, as Common Article 3 of the Geneva Conventions require, and to satisfy due process and the Eighth Amendment prohibition on cruel and unusual punishment under U.S. Supreme Court law, you have to have a highly effective and working court system, among many other things. And this, for a variety of reasons, is not.
Whatever occurs, whatever verdict occurs, your client is not going to be released, is he?
Oh, that's absolutely clear. He'll never be released. If he were found not guilty of any involvement in September 11th, he would still be held for the rest of his life. I have every confidence.
And how has this changed you?
I don't think it's changed me too much. It's changed the way I practice, and it's exposed me to a lot of interesting aspects of practice that I had not been exposed to before, and it's been very interesting, very professionally challenging. But at the end of the day, it's the provision of a good defense, and it's scouring every grain of sand to be sure that there's nothing that's been left behind. It's really the same process, just on a much bigger scale.
Well, thank you. Thank you for taking time to talk about it, and I'd like to check in with you again, because I find it so interesting. And of course, I don't think the American public is really much aware of what's going on.
Yeah, I think not. I appreciate your interest. Thanks. It's a pleasure being here.
Thank you very much. You've been listening to David Nevin. He is the lead defense counsel for Khalid Sheikh Mohammed, who is accused of being one of the people who planned the attacks on 9/11. For more information, go to the Dialogue website. Just go to idahoptv.org and click on Dialogue. For Dialogue, I'm Marcia Franklin. Thank you.
Presentation of Dialogue on Idaho Public Television is made possible through the generous support of the Laura Moore Cunningham Foundation, committed to fulfilling the Moore family's legacy of building the great state of Idaho.